Losing a family member in a crash is devastating, and what makes it worse is knowing someone else caused it, but no one's given you a straight answer about what you can actually do. You're left grieving, stuck in paperwork, and unsure if you can even hold the driver accountable. I'm Guy DiMartino. I've helped Indiana families in this exact situation, and yes, there are specific legal routes that let you sue after a wrongful death. This video walks you through what these options are, so you're not left in the dark while the at-fault driver walks away untouched. If you're watching this, it probably means your family is reeling from tragedy. In Indiana, not everyone can file a lawsuit after losing a loved one in a car accident. The law is pretty specific about who is allowed to sue. Here's what you need to know. Indiana calls this a wrongful death claim. The actual lawsuit must be filed by the personal representative of your loved one's estate. That's usually the person named as the executor in a will, or if there's no will, somebody appointed by the court. But here's what matters for families. The people who benefit from a successful lawsuit are the deceased person's surviving spouse, children, or eligible dependents. If there's no spouse or children, sometimes parents can benefit. The personal representative is just the person who handles things in court, but the money awarded goes to the family. Let me give you an example. Let's say a husband dies in a car crash caused by a distracted driver. If you're his wife, you'd work with the estate's personal representative, who might also be you, to bring the case. If your brother passes away but left behind 2 young kids, the case is filed by the estate, and any compensation would go to his children. If you're unsure about your relationship to the person who died, or you're not sure if you're allowed to participate in a wrongful death suit, it's best to talk to an attorney right away, and so then you will understand where you fit in. We can help you sort out the details and make sure your family's rights are protected. Let's talk about what you actually have to show in court to win this kind of lawsuit. Indiana law says you have to prove a few key things. These are called elements. The first thing is the other driver was at fault, meaning they did something wrong like texting, speeding, or running a red light. The next is the wrongful act or the crash caused or led to your loved one's death. It can happen at the scene. It can happen shortly after the accident. It can happen months down the road, depending upon the nature and extent of the injuries. And 3, that your family suffered loss as a result of the accident. It's not enough to simply know the other driver was involved. You need evidence to prove the case. This could be in police reports, witness statements, or even traffic camera footage. I've seen cases where the at-fault driver was drunk and the evidence was clear-cut. Breathalyzer results, field sobriety tests, witness accounts, but sometimes it's just not as obvious. Maybe the other driver was just careless, or the weather was bad, or both drivers made mistakes which led to the accident. Indiana follows what we call comparative fault. If your loved one was partly at fault, you can still recover money as long as the other driver was more at fault than your family member. That is comparative fault. The amount you'll receive will be reduced by your loved one's share of fault. For example, if the court or a jury finds that the at-fault driver was 80% responsible and your loved one was 20% responsible, your damages would be reduced by 20%. But if it's determined by a jury or a judge that your loved one was more than 50% at fault, unfortunately, you cannot collect anything in the state of Indiana. So evidence is the key. It's important to collect as much information as possible after the crash and to talk to an attorney before speaking with insurance companies. Now you're probably wondering, if you do sue the at-fault driver, what exactly can your family recover? In Indiana, it depends upon the age of the person who died and their relationship to you. Let's break it down simply. If your loved one was an adult with a spouse or dependent children, you could recover lost income and benefits, what they would have earned if they had lived, medical expenses, funeral expenses, the loss of their loved care and companionship. For unmarried adults without dependents, Indiana law sets a limit or cap on how much can be recovered right now. It's $300,000 for non-economic damages, and that is for the loss of love and companionship. For children under the age of 20 or under the age of 23 if they're in college, there's no cap, and the parents can sue for the loss of their child's services, love, companionship, plus medical and any funeral costs. Let me tell you about a recent example. I helped a family after a young mother was killed by a reckless driver. She left behind 2 small children. We were able to recover money for her lost future income, what she would have earned until retirement, as well as significant compensation for the emotional loss for her children. The money went into a trust for the children's upbringing and future education. It's not about getting rich. No amount of money can bring someone back who has passed away, but these funds can help keep your family steady after a traumatic loss, especially if you lost a breadwinner or need to pay for counseling and support. Here's something a lot of people don't realize. The at-fault driver isn't always the only person or company you can sue. Usually, the lawsuit is against the driver who caused the crash, but sometimes there are other responsible parties. The driver's employer, if the driver was working at the time, like a delivery driver or trucker, you may be able to sue their company also. The vehicle owner, if the at-fault driver was driving someone else's car, the owner might also be responsible, especially if they let someone reckless or an unlicensed person borrow their vehicle. Bars or restaurants in Indiana have some potential culpability if someone is overserved alcohol at the bar and then causes a fatal crash. The bar or restaurant could be held liable. Car manufacturers or repair shops, if a car has a defect or a botched repair and that contributed to the crash, they could be on the hook for some of the damages. Governmental entities on rare occasions, if there's a poor road design or lack of sign and that caused the accident, a city or county might be liable, but suing the government has stricter time limits and notice requirements. I represented a family whose loved one died when a semi-truck failed to stop at a red light. We sued both the truck driver and the company, showing the company pushed their drivers to ignore safety rules. That led to a much larger settlement than if we just sue the driver alone. Identifying all responsible parties can make a huge difference in your recovery. That's why you need an attorney who really digs into the details of your case. How long does it take to file a wrongful death lawsuit in Indiana? That's an important question and something that you really should know. Indiana law only gives you 2 years from the date of your loved one's death to file a wrongful death claim. That might sound like plenty of time, but it goes by faster than you think, especially when you're grieving, dealing with insurance, medical bills, and funeral arrangements. Even more, if you're thinking about suing a governmental entity for a bad road or a negligent city or county employee, you usually have much less time. You have about 180 days to give notice to the government of your claim. If it's the state, it's a little bit longer. I've seen families lose out on their chance to recover compensation simply because they waited too long or didn't realize what the deadline was if you're going to bring a claim against a municipality or the state of Indiana. Even if you're not sure you want to sue or you're still gathering information, it's a smart idea to talk to a lawyer as soon as you can. We can help you meet the deadlines and protect your rights so you don't lose your chance forever. Sadly, many Indiana drivers carry only the minimum required car insurance. and that minimum may not even come close to covering your family's losses. If the at-fault driver's insurance runs out, what can you do? There are some options. Your loved one's own insurance, if they had uninsured or underinsured motorist coverage, which is often called or UIM, you may be able to make a claim on that policy. This is extra coverage most people don't think about until tragedy strikes. Suing the driver personally, you can try to collect from the driver's personal assets. Sometimes if they have a home or savings, you can collect from those. But often, if they don't have much, you may not be able to recover additional money. There might be some other responsible parties, like I mentioned earlier. If it's a business or a bar or another deep-pocketed defendant and they share blame, you can sue them to receive compensation. It's important to have an attorney who can hunt down every possible source of recovery. We look at all the insurance policies involved, investigate the other parties, and fight to get every dollar that your family deserves. You might be picturing a long, stressful trial. In reality, most Indiana wrongful death suits settle out of court. That means you probably won't have to testify in front of a jury unless liability is hotly disputed. So here's how the process usually works. First, there is an investigation. We gather evidence, review police reports, talk to witnesses, and sometimes work with accident reconstruction experts. Next, filing the lawsuit. The personal representative files a complaint in court. The third step is we talk to the other side, present your case, and try to reach a fair settlement. And if that doesn't work, then we have to go to trial. If the other side refuses to pay what's fair, then it's just up to a jury or a judge to decide how much your family gets. But again, most cases settle before reaching this stage. Throughout the process, you and your family are in the driver's seat. We handle the heavy lifting, but ultimately you decide if and when to settle your case. Losing a loved one is overwhelming, but you don't have to do this alone. Here's what I recommend if you're thinking about suing the at-fault driver after a fatal car crash in Indiana. Gather all the paperwork you can. Police reports, insurance info, medical bills, funeral costs. Write down everything you remember about the accident. Collect any photos or witnesses' names. Contact an experienced Indiana wrongful death lawyer as soon as possible, even if you're not ready to take action right now. The sooner you reach out, the better your chances of protecting your family's rights and getting the help you need. We can give you straight answers, explain all your options, and fight for justice on your behalf. We've covered who can sue the at-fault driver if your family member died in an Indiana car crash, what you need to prove, what compensation you can recover, who you can sue, and why acting fast is critical. But to really stack the deck in your favor, you'll want to watch my next video, The 5 Secrets to Making Your Car Accident Claim Easy. Don't miss it. In that video, I'll break down the simple moves that give you the edge and avoid mistakes that can cost you thousands. Click now to watch and protect your family's rights starting today. I'll see you over there.